Morning, everyone. Good evening, good afternoon. I'm Professor Malik Dalan, the Chair of International Law and Public Policy at Queen Mary University of London, Honorary Professor at SUBE, the School of Negotiations, Trade Negotiations, and Principal of Institution Quraysh. Before I start, I just wanted to mention a few housekeeping points. Please make sure that you're on mute. Please also note that we will be following the schedule strictly. So any questions that you may have, you can write in the chat or the Q&A box. Again, I see some of you not having your mute button on, so please, so that we can avoid interference. So let me start by welcoming this very, very distinguished group of speakers and welcoming you all, and begin this session. As a result of the controversial questions surrounding the future of global trade, including trade fragmentation, trade wars, the biggest question for 2021, as stated by many think tanks in the US, the China-US decoupling, and the UK membership in the European Union or lack of, and questions about Scotland, which has given rise to intense international law and governance debates in a number of fora. IQ, Institution Quraysh, has partnered with several organizations to set up an independent forum for academics and practitioners to debate and define the positive role of international trade relations through the creation of a Council on Trade and Diplomacy. The first of which is meant to focus on the China Forum, which aims to provide a comprehensive and ongoing understanding of trade and diplomacy in international governance, law, and policy practices and foreign relations. A framework of international, national, and subnational law governs state relations in trade and investment and is a fundamental factor in determining whether, when, and how states and economies can benefit from those relationships, capital flows, and supply chains. Our partners, SUBE School of Trade Negotiations and the WTO Chair Institute in China, is the first partner and as the first specialized institution in China to cultivate trade negotiators. The School of Trade Negotiations was established in 2017. Its predecessor was the School of WTO Research and Education, SWTO, established in 2002. Which was one of the earliest academic institutions in China to carry out the WTO research and education. The school is also one of the 19 WTO chairs institutes selected by the WTO, and it's the only one in China. As the host institute of WTO chairs, the chairs program in China, the school has developed itself to be a core institute and participant in the global academic network of the WTO Secretariat, and has gradually become an internationally renowned academic institution in trade and investment related topics. Secondly, the Jean Monnet Network, EU-China Legal and Judicial Cooperation, EUPLANT, sorry, can I ask you to mute your, yes, thank you. The interactions between the Chinese and the European Union, legal and judicial systems, and promotes excellence in teaching and research on EU-China legal and judicial cooperation. Through a set of research, policy, and outreach activities, EUPLANT creates new avenues for enhanced academic and policy cooperation between the EU and China, and engenders better understanding of each other's legal systems. Partner universities of EUPLANT include QMUL, Queen Mary University of London, which is the coordinator among many others, and of course, At Queen Mary University of London, we have launched a trade initiative which is at its infancy, which is co-led by myself and Dr. Gabriel Gary, with a new journal expected in the future, as well as the Trade Lab. I'm also happy that we've established a cluster of experts, of course, with our dear Dr. Mathieu Burnet at the law school itself. And I feel that as we continue with this important debate, and today we are 2 days ahead of the United States inauguration of the new president, which will be important to set the trade agenda going forward. We hope this conversation with European colleagues will help inform, if only informally, a rich agenda to be thought about in the coming 4 years. So let me not delay you anymore and kick this forum, the China Forum on Global Trade and Investment Law, by asking my my colleague, Dr. Burnet, Associate Professor in Global Law at Queen Mary University of London and Academic Coordinator of the Jean Monnet Network on EU-China legal and judicial cooperation, to begin the panel. Thank you very much, and I hope you have an enriching and an enjoyable day.
Many thanks, Professor Dalan, for indeed introducing the forum. A very good morning, dear colleagues. It is a real pleasure for me to get the opportunity and the chance to chair this first session, which will focus on WTO reform and China's role therein. At a time where the WTO still constitutes, the main institutional and normative cornerstone of multilateral trade governance, it is very important to recognize that the three key components of the WTO are now in a deep state of crisis. Whether we talk about the role played by the WTO in terms of being the main negotiation forum for the further liberalization of international trade, whether we talk about the WTO as the main place for trade policies monitoring, or the importance of the WTO in terms of resolving trade disputes between WTO members, the least that we can say is that the WTO is in a difficult situation. The purpose of this panel is to analyze specifically and to critically assess the role played by China in the midst of this crisis. Ever since it became a member of the World Trade Organization back in 2001, China's WTO policy has become increasingly active. China has now the ambition to increase its discourse power and to become a maker and shaper of legal norms in the context of international trade rules, rather than a norm taker. A number of questions have to be answered, and for that purpose, we have the pleasure here to welcome two distinguished speakers, as well as a discussant who I would like to very briefly introduce now before giving them the floor. We'll first start with a presentation by Professor Gong Beihua. Professor Gong was a professor of international law in the Law School of Fudan University, as well as the Associate Dean of Shanghai Advanced Institute for Lawyers of Fudan University. He also serves as a chair of international law in the international law section of Shanghai Law Society. Professor Gong will give us a presentation on WTO reform negotiation. What is the position of China and the US? ? His presentation will be followed by a second presentation by Dr. Wto Reform. Dr. Wto will make a presentation on China's high-tech policies and subsidies, current WTO rules, and future negotiations of industrial subsidies. Dr. Wto is an associate professor as well as director of research at the China International Business and Economic Law Center at UNSW in Sydney. These two presentations will then be followed by a discussion, by some comments by our colleague Dr. Luca Rubini, who is an associate professor in international economic law at the University of Birmingham in the UK. I just would like to mention here that his work on subsidy, state aid, and WTO has just been translated into Chinese. Without any kind of further ado, it's now my pleasure to give the floor to Professor Gong for his presentation on the WTO reform negotiation. Professor Gong, the floor is yours. Thank you very much.
Okay, thank you for Mr. Moderator. Let me first share the slides with you so it's make more easy to understand it. So you can read it or you can see it. I just make
we
sure.
Can.
Oh, good. Okay. I should say good evening, good afternoon, good morning. Yeah, I just repeat them. I'm Gong Baihua from Law School, Fudan University, and I would like to share some information or ideas about the WTO reform negotiations, especially what's the position of China. Of course, I have to compare it to US position, but I focus on the position of China. Okay, I will limit my presentation within 15 minutes. So first, let me very briefly to mention about WTO and China. You may know China accessed into WTO in the year 2001. Actually, this year will be 20th anniversary. The exact date is December 10th. So I believe this is a milestone for China to integrate into economical globalization and marking a new historic stage of reform and opening up. So since China's accession to WTO, that boosts China's development and, of course, benefit the rest of the world. So since the accession to WTO, China has accelerated its reform, no matter you recognize it or not, and opening up process and economic growth. So China's development is a forceful driver for global economic growth. At the very beginning, some professor already mentioned that this year the GDP, China's GDP grows. So it's almost every year 30% the contribution to the global economic growth. So that's wonderful. So of course, I think different people, different countries have a different view on that. Maybe you already knows that USTR just have a new report on China's WTO compliance about WTO. I don't want to discuss the detail here, but I think different people maybe have different view on the same facts. So for me, I think most important things for China as a law professor, legal professions, is the China admit and knows they change the game room. They will try to follow the international standards. So you will see the picture. China used to play ping pong. It's very good at that, but they not expect every country, every member to play ping pong. So they shift to play golf. Of course, China also very good at play Chinese chess, but most of the WTO member play the international chess. So we have to learn that. Now we learn very quickly, very fast. But somebody worry about, no, you're not supposed to good at international chess. You're not supposed to good at golf. Maybe you are cheating. So I don't talking about that. I just leave that here. So what's the WTO? WTO have big problem. Why? Because WTO now is capitalism. No capitalism in tribal water and with no land inside. So big problems. So who did that? Maybe that guy, I'm not sure. Anyway, he will not be there for longer. So what's the current WTO? The three functions of WTO, the moderator already mentioned that. Maybe trade policy review, it seems good, but they still have some problem like transparency. Rule negotiation stopped. Dispute settlement out of service. So we have a bigger problem right now. So what shall we do? We need reform. We need a modernization of the rule. But who wants the reform? why we should reform the WTO? What kind of thing we can reform? How can we reform? I think these questions maybe lead this night or this morning to discuss about that. So we have to think very deep, not only on the simple facts. Let me first mention the U.S. position on the reform. Unfortunately, USA no systematic system. Even though he asked very loudly, WTO need reform, but they never produced their position paper. So I just only can read from like 2019's trade policy agenda and can find some hints what they are thinking about WTO reform. Maybe I'm wrong. I just conclude that. First, they want to say what? They want the WTO must address the unanticipated challenges of no market economies. You understand? Target which country? I don't want to mention it. You maybe already know that. So they produced some text for market-oriented conditions, 8 conditions. I don't want to go to details. But if you consider about 8 conditions, not only China, I think Russia, Vietnam, I'm not sure UK, USA itself could be market-oriented members. So there's no rule there. They want to produce new rules without negotiation. But they asked only one particular country have to meet these conditions, but they don't think about Russia, Vietnam, or other members, maybe Australia also. So second, the proposal is WTO dispute settlements must fully respect the members' sovereign policy choice. It sounds good, but it looks like that they're unhappy about they lost the cases. If they lost the case, there's violate their sovereignty. So you're very interesting. Only developing countries quite worried about sovereignty. At the very beginning, I think China went into WTO, they worried about dispute settlement maybe violate Chinese sovereignty. But now US saying that. So it's very interesting. There is 6 concerns. I do not want to go to the details. If they really want to solve the problem, these 6 concerns is not so difficult to solve it. Third one is WTO members must be compelled to adhere to notification and obligation. This one, I totally agree with that. WTO trade policy review needed to transparency, needed to follow the notification procedures. They cannot always behind the schedule. This is okay. And the fourth one, the WTO treatment of development must be revamped to reflect current global trade reality. If we take speaking generally, it's okay, but it's the particularly target China, I think is unfair. So the USA produced an undifferentiated WTO documents, say so-called self-declared development status. But it's not only China. I think many like South Korea, even Israel, they used to be developed country. Yes, we needed to reform that, but we needed to through negotiation. That's basically maybe U.S. position. I'm not sure because they never produced the officially put paper on that. So now I shift to Chinese position on WTO. Actually, I'm saying China is too hurried to produce their position because UAE is always hide behind. Why you should put your position so fast? Anyway, in the year 2018, China issued a position paper on WTO reform. So the following year, China's delegation to the WTO submitted a proposal on WTO. Generally speaking, there rest 3 principles, so-called 3 basic principles and 5 suggestions. I just one by one very quickly. Firstly, the WTO reform shall preserve the core values of the multilateral trade system. It's okay. I think everybody will agree on that. Second one, the WTO reform shall safeguard the development interests of developing members. maybe then it's arguable, especially I think in the United States, I argue about that. And third, the WTO reform shall follow the practice of decision making by consensus. That's a troublemaker, especially on consensus, how to understand consensus. If it means every members, 164 members, have to agree upon that, it's very difficult to pass any new agreement, any new solution. 5 suggestions, just follow the 3 principles. Firstly, the WTO reform should uphold the promises of the multilateral trade system, almost repeat the first principle. Secondly, the priority of the reform is to address the existing problems faced by the WTO. Actually, China refers to WTO dispute settlement, applicable body crisis. Thirdly, the reform should address the imbalance of trade rules and respond to the latest development of our time. Yes, we recognize we have new problems like e-commerce and other things. We have to respond for that. Fourthly, the reform should safeguard the special and differential treatment for developing members. That could be a big argument for that. The last but not least, the reform should respect members' development models, so they can choose their own way to develop. That's basically Chinese position on WTO reform. So I just gave some comments for that. For China, I think WTO remain the cornerstone of economic globalization and trade liberalization, and the pillar of global economic governance. So it does recognize that WTO is not perfect, imperfect, and needed to be improved, especially like negotiation, the way, and the transparency. China is willing to advance WTO reform. However, China does not want this reform to be a revolution, not to be revolutionary. That could be very difficult to undermine the long-standing principle of this organization, like no discrimination, consensus, and development. So China wants a WTO reform, but not a China reform. So WTO reform cannot be targeted as a specific member. That means China. So you cannot that way. The effective function of the dispute settlement mechanism is a precondition to valuable rule-based world trade system. So you cannot talk too far to talk about go to the moon. You should talk about what you need to have to settle the problems. That's the dispute settlement, applicable body problems. So China's proposal is concerned with the misuse of new protectionist measures taken on the pretext of national security exceptions. So right and recently, this becomes a bigger problem. They use national security exclusion to violate the trade principles. So China calls for maintained the special and differential treatment for developing members to strengthen the inclusive of the multilateral trade system. China wants its developing countries status, but yet ready to make more contribution. So you should understand that. That means China could be flexible on this one, but we still want to keep that. But in the future negotiation, China could be flexible on that. So, because if you were talking about China, you just mentioned GDP in total, but if you're talking about GDP per capita, China is a poor country. Make sure that is. So you have to how to read it. So actually, developing country members' status is not only an economic issue; it's a political issue. It's not easy to solve the problem so fast. It's not the first one have to deal with. I know EU already produced some like a graduation of the developing members. We can discuss it, but it's very difficult to realize that. And China also fully aware that the WTO needs to keep up with times. So, for example, like some old-fashioned rules on agriculture. They need to reform, like fishery subsidy. We need to finish the negotiation. And also we needed to talk about cross-border digital trade issues. That's China actively and welcome to negotiate on these ones. And China even actively participated in plurilateral liberalization initiative, like ITA negotiation, also about environmental products agreement. I think new U.S. president were quite interested on this issue. It's a key areas. Maybe China and the U.S. and other members can cooperate on that. So China is tried hard to join the GPA. So actually China did a lot, not like USTA reports, 100% poor, bad. You have to be neutral for that. Okay, I don't want to go too more about that. So because today this forum is organized by the trade negotiation school. So we will follow a negotiation words like ZOOP. ZOOP means Zone of Possible Agreement. So what is the ZOOP for the WTO reform? China, USA, EU, India. If there's no ZOOP, there's no possibility, no result. So maybe at the very beginning we have no ZOOP, but we have to work out. Finally, we will find some ZOOP. So what's the way to find the ZOOP? Compromise. So compromise is very important. And what's compromise? You can choose. You have play A. You have to have play B or play C. So compromise is not a dirty word. Life depends on compromise. I think it's I borrowed this was from UK May, Prime Minister May, before her leaving his office. So WTO reform and modernization depends on compromise. So the problem is how, when, what we can compromise that. This is we think about. Now comes Biden, USA new president. So this is a window opportunity. I'm not sure that they will close the window or open the door, but it's not easy because globalization will give you opportunity, also will bring competition. But in the United States, some people, they don't like competition. Of course, that they like opportunity. Especially, they are not on the high place of competition. They will find some way, like some words to say this unfair competition. So we need to very realize what's the fair, what's unfair competition. That's we need to work together to find the new rules. So I'm not blaming anybody, but we have to be calm down to sit down to find the rule, the reality rules. But finally, I still think US and China is most two important WTO members to drive the WTO reform forward. There's two wheels. Of course, US is the front wheel. China should be follow that, but we need to keep it balanced. Okay, I almost used up my time. Thank you for attention. Okay, I finished my presentation. Thank you.
Many thanks, Professor Gong, for this very comprehensive and thought-provoking presentation, which did very well set the scene on the US and Chinese perspectives on WTO reforms. Without any kind of further ado, I would like to give indeed the floor to our next speaker, Dr. Zhao. Dr. Zhao, the floor is yours. Thank you.
Thanks, Bernie. And let me just start by thanking the organizers for inviting me. And it is a great pleasure to join a group of distinguished speakers and commentators. And thanks, Professor Bernie, for a kind of introduction just now. And I must say, the last thanks that goes to Professor Rubini, that it's so great to have you as a commentator in this panel, as you can see from the title of my presentation. I'm just trying to work out how to change the slide. Okay. So what I'm going to talk about today is really based on a paper we finalized end of last year. on Chinese subsidies in the high-tech sector, the use of WTO rules to deal with these subsidies, and the future negotiations of industry subsidies more generally. So I will run through each of the sections briefly. And the paper is quite long, just because that we're trying to really dig into it. And it's about 35,000 words, and I'm not sure whether it has been circulated, but I will provide a link at the end of the presentation. So if you're interested, you can have a look. So what I'm saying is that I'm going to try to squeeze the 35,000 words into 15 minutes in my talk. Before I get into the specifics of Chinese industry subsidies and policies in the high-tech sector, which we use as an illustration, but most of what we have to say today is really, I think, applicable to subsidies in other sectors. So, so before I get into the specifics, I think I'm just going to summarize some of the general observations. I think the objective assessment of China's subsidies and industry policies needs to be considered in the historical context. First observation is that technological advancement is critical for economic growth across all economies at all stages of development. Governments of developed and developing countries alike have constantly resorted to a mix of policy instruments, including direct and indirect financial and non-financial support, to promote research and development and innovation, and to create national champions in strategically important high-tech sectors. Industry policies in selected sectors have been common and have played a crucial role in helping countries to do technological catch-up. In that endeavor, governments and public entities have played a vital role in promoting and implementing these policies, triggering competitive government intervention, including subsidies on many occasions. That includes EU and the US and Japan and the US back in the 1980s. So the second observation, WTO rules do not restrict members' sovereignty in pursuing any preferred economic structure and development model. However, the development of the multilateral trading system has created more discipline on the use of subsidies in pursuit of legitimate regulatory goals. The WTO agreement on subsidies and countervailing measures came out of a compromise. Professor Gong was talking about compromise, but the subsidy agreement itself was a really big compromise between essentially regulating trade distortive subsidies and protecting policy space. The need to strike a balance between the two competing interests remains current and controversial today. So I will come back to this point in talking about the general principles we propose for the future negotiations later on. The third observation, because of the increased regulation, one may argue that compared with the regulatory freedom that countries used to have in pursuit of technology and innovation-based economic growth, China and other economies still in the process of technological catch-up have relatively limited policy space today, especially when we take into account China's extensive WTO plus obligations. Again, I will come back to that point when I talk about the adequacy of the WTO rules in dealing with Chinese subsidies. The fourth observation is about COVID. So when COVID hit us, industry subsidies and policies are certainly become more crucial to economic recovery and the welfare of all nations. Their economic political implications, however, should not be underestimated. The pandemic has had significant impacts on all economies and will likely have enduring impacts. At the same time, such enduring impacts will also flow from industry policies and the subsidies used to combat the pandemic. In many ways, the pandemic has intensified the trend of deglobalization due to the growth and expansion of economic and political tensions and the rise of economic nationalism, and consequently, the resort to bigger labor and tit-for-tat policies and the shift from international cooperation to unilateralism. So my final point also relates to pandemic, is that while we're dealing with the pandemic, it must be recognized that many of the systematic and fundamental problems faced by the WTO predate the pandemic and will persist after it, including industry policies and subsidies, including state-owned enterprises, and including non-market economies more broadly. So therefore, solutions to the pandemic or the pandemic-related subsidies industry policies may not be sufficient responses to these issues, even though the pandemic may provide a golden opportunity, as I believe, for governments to rebuild the political will for international cooperation. Now, in the next 2 slides, what I'm showing is basically a couple of diagrams just show the rise of protectionist measures and subsidies even before the pandemic. But certainly, the further expensive use of industry subsidies and other trade restorative measures during the pandemic should really push governments to rethink the ways to deal with subsidies through cooperation rather than competition. Now, let me just get into China's subsidies and industry policies. Now, the paper does a really very comprehensive review of the evolution of China's high-tech policies and subsidies, and really dig into the major types of subsidies. I don't really have time to talk through them. But let me just, again, to provide some brief observations. The first point is to say that technology advancement and innovation has been an integral element of China's national policy for economic reform and development for at least 6 decades. It is both unrealistic and unreasonable to expect or even force China to abandon the technology-oriented growth model. China's latest policy development has amply demonstrated its entrenched commitment to strengthen, refine, and upgrade policy priorities and strategies in support of technology and innovation-based economic development and digital transformation. As we will see soon in this year, that the 14th five-year plan will come out and will really set out what has already been set out before in the end of last year about the new policies and the growth model in the future, which really continue to emphasize on technology development. And in relation to the subsidies, again, as I said, we provide a detailed overview of the subsidies in light of the WTO subsidy rules. That allows us to show whether the WTO rules are adequate to capture these subsidies. In relation to the actual subsidies, we show that the major Chinese subsidies in the high-tech sector are actually quite standard and evident, as opposed to the wide observation that Chinese subsidies are often complex and hidden, making it difficult to identify and prove the existence of subsidies under the WTO rules. These subsidies are mainly in the form of grants and direct payments, policy loans and guarantees, equity infusion, provision and purchase of goods, sometimes through SOEs. So given the current WTO jurisprudence, I don't think it's difficult at all to find these subsidies to be financial contributions. Now, I know there has been some debates about indirect subsidies, but I will come back briefly to that point later on. Now, I've talked about the subsidies and also financial contribution. Now, let me just move to the WTO rules very briefly. Again, this is really the major parts of the paper, and it's really a major contribution of the paper, which provides a detailed discussion of the relevant WTO jurisprudence and application to the Chinese high-tech subsidies. Now, again, these discussions could apply to other subsidies in other sectors. Okay, we do not find such a detailed discussion in the literature, even though bizarre that we all have been overwhelmed by allegations that WTO rules are insufficient in addressing Chinese subsidies. We believe these allegations are untenable, and our discussions in the paper have challenged the conventional wisdom, if you like. Now, let me just touch upon the other 3 elements very quickly. Just provides a bit observation. The first, on the public body, which is perhaps the most debated element under the definition of subsidies. The thing I want to say is that the criticism about the panel body's function and authority-based approach has overlooked the probability that the ownership-based approach would attract at least equally intensive criticism, as it does not distinguish between actions of the government and actions of the entity. Second point, it has also overstated the evidentiary difficulties in proving Chinese SOEs as public bodies. In both cases in which the authority-based approach was developed and applied, being DS 379 and DS 437, the tribunals did not disagree with the investigating authorities on the findings that the evidence on the record was sufficient to show China's state banks in DS 379 and SOEs and state-invested enterprises provide inputs to manufacture in DS 437 were meaningfully controlled by the Chinese government to exercise governmental functions. So if one wants to say that the evidence is really can't be overcome, the challenges, then it is not true, right? In both cases, the patent body agrees that the evidence is enough. Now, on the elements of benefits conferred, the difficulties may arise in dealing with a market with significant government intervention. The difficulties are twofold. The first is the identification of a competitive benchmark. And the second is making adjustments to that benchmark used to ensure. These difficulties, however, apply to all WTO members. In the case of China, we have additional rules set out in Section 15B of the Accession Protocol, allowing flexibilities for investigating authorities to use external benchmarks, so hit the first difficulty, and not making adjustments if it is not practicable to do so, so hit the second difficulty. So I will show you the text of Section 15B in the next slides. But again, it is a common problem, but the China's WTO Plus obligations do provide some solutions and flexibilities. Third point on the specificity. Now, again, a very complex element with us a detailed analysis in the paper. But what I want to say here is just say that either it is a national subsidy or a local subsidy, talking about subsidies in the high-tech sector, China's industry policies mandate the provision of the subsidies to selected sectors and sometimes enterprises. So if it is a written instrument provided subsidy, then it shouldn't be difficult to find that it's either enterprise specific or regional specific. Now, a major difficulty that may arise is where there is no written instrument, so that a de facto specificity needs to be established. This typically occurs in the context of the provision of goods, especially input to manufacture through state-owned enterprises. There is no document to mandate the SOEs to provide instrument, to provide the inputs at less than adequate remuneration. However, this difficulty again applies to all members. In addition, one could make an argument that the source of the distortions lies in the subsidies and preferential treatment provided to SOEs, enabling them to supply production input for less than adequate remuneration. Therefore, one way to deal with the subsidies to downstream industries would be to address the source of the problem, that is to push China to reduce or remove the subsidies to SOEs. In this regard, Section 10.2 of China's Accession Protocol again allows WTO members to deem Chinese subsidies to SOEs as being specific. So given the dominant role of SOEs in the major upstream industries and the large amount of subsidies they receive, this WTO Plus commitment would mean that any subsidies provided to SOEs in these sectors would be specific. Again, talking about the high-tech sector, but that could be generally applicable. All right, so that's basically how much I want to say, but in the paper itself, it runs through about 30 pages. Now, I just want to go through very quickly about the China Plus obligations I've just mentioned. Some of you might have already be aware of them, and I don't want to kind of repeat my arguments. We presented some arguments in a different paper when we deal with the SOEs, but here I think it's still applicable. So I just reproduce some of the provisions there. On these slides, especially the specificity rule for SOEs under 10.2 and 15B, you can see the flexibilities that provides to investigating authorities. Sorry. The next one, even broader, is Article 6.1 of the Accession Protocol plus paragraph 46 of the Working Party report, which is essentially expansion of Article 17 of the GATT on the state trading enterprises. If you read the texts, now some of you may know that the patent body basically says that GATT Article 17 applies to non-discrimination only, right? But you can make an argument that this paragraph 46 of the Working Party report sets out a WTO plus obligation mandates China to ensure that state-owned enterprises and state-invested enterprises make purchases and sales solely on commercial considerations. So again, whether this paragraph can actually be used to deal with SOEs providing input for manufacturing at less than adequate remuneration, I mean, hasn't been tested before. This clause has never been invoked before. So this is one of the arguments you can make that even without using these broad obligations of China, people are actually arguing the rules are inadequate. The next one, you might find it's more broad, right? It deals with the price in every sector, right? It says that the price in every sector, including goods and services, needs to be determined by market forces. Never used before. Yet it provides the scope, as we can see. It depends on how the tribunals interpret it. But again, never used, despite the overwhelming criticism of insufficient WTO rules to deal with China subsidies. So I will just stop there and just show you that. But finally, apart from the rules discussed above, let's not forget that in the past cases, the national treatment rule, China's WTO plus obligations on export taxes have also been applied to successfully challenge China's subsidies and measures having an effect of subsidies such as export taxes on raw materials and rare earths. Right, that has been argued in Bang and Hillman's paper as indirect subsidy, and there is no WTO discipline. But in case of China, actually, we do have a discipline, which is that all export taxes, except for very limited list of exception, China cannot use export taxes, while all other WTO members may use export taxes for their regulatory goals. Now, so that's the rules. Happy to discuss further later on, but let me just finally touch upon negotiation, right? So what's the way forward?
Dr. Zhao, sorry, may I kindly ask you to conclude or to be quite quick with this part because we need to turn to the discussion. Thank you.
Sorry about that. Well, very quick, right? So 3 points. First, I think as Professor Gong said, negotiation must not disproportionately focus on China. As we discussed, most of the problems apply to all WTO members. And targeting China will have some counter-effective, will be counter-effective. The second, we need to strike a balance. I think this is the question I want to ask Professor Rubini. It's about how we're going to use the specificity and targeting rule to guide the future negotiation of industry subsidies and distinguish between good and bad subsidies. But finally, which I think is kind of innovative, but correct me if I'm wrong, is that we think that we need to deviate from the one-size-fits-all approach by adopting a scheduling approach for industry subsidies negotiation, so that the schedule, it's like a goods schedule and service schedule. You have an individual schedule for individual countries. So you can set out your objectives, your subsidies, and the amount of subsidies, and phase out and phase down periods, and all sorts of stuff that to reflect the diverse political and economic situations in different countries. So I'll just stop there. And thanks for the opportunity. And the paper is downloadable from the SSRN and also other materials if you're interested. Happy to discuss further.
Many thanks, Dr. Zhao, for this very, comprehensive and detailed presentation. If I may suggest, don't hesitate to post the link to the paper on the chat so that, our audience can get a direct access to it. Dr. Rubini, the floor is yours for the discussion. Thank you.
Thank you very much. Thank you to the organizers for giving me this opportunity. I have to say immediately that I really enjoyed both papers. The first one is very interesting because of the general principles, non-legal principles that should basically regulate the process forward in possible renegotiations of the WTO rules. The second one by Professor Zhu is very, very detailed. I had the pleasure to browse through this long paper, and there is really much, a lot there to comment. So 10 minutes is really a big fit. I will nonetheless try to provide comments, general comments, 3 or 4 general comments, and hope this may be useful. First thing, and here I'm really addressing a point made by Professor Gong. Is it appropriate? I'm not saying is it correct, but is it appropriate to phrase a possible review of the WTO legal system in terms of a China focus only, or even worse, a China problem only? Well, my simple answer is no. This is not appropriate. This would be a non-starter politically, and you have clearly seen it in the very clear presentation of Professor Gong. Naturally, China would say, I'm sorry, I'm not participating into this game, a blaming game. Having said that, there are clearly general issues, and this has been highlighted also by Professor Zhu in his paper, that predate the pandemic, and these are not only concerning subsidies, that general issues that have to be addressed together, so they are not necessarily China-specific. Having said that, there is clearly a footnote. The tremendous achievement and the tremendous emergence of China in the world trading system in the last 10, 15 years has raised a few concerns. Whether these concerns are politically or economically or legally grounded or not, well, this is open to debate. I particularly enjoyed the 2 presentations, and especially the paper by Dr. Zhu, because he's able, by providing evidence, to dispel, or at least he tries to dispel, some myths, some rhetoric. So I really encourage you to publish this paper. I very much like the discussion on the public body. Clearly over there, I don't want to enter into much into technicalities. The problem is not only the standard that was discussed before the legal the dispute settlement, but the problem is a problem of evidence. And it is linked to a major concern or criticism that there would be particular issue of transparency in China because of the particular corporate governance system. A particular role, a special role that is played in particular by the party. And clearly this is open to discussion. It doesn't make the whole discussion about WTO reform a China focus or a China problem, but this will come out in the negotiation. But having said that, the approach should be a general one. There are general issues because the rules, the multilateral rules were negotiated too much way back ago in the past. We are talking about 35, 40 years ago, and the balance of interest has to be revisited. Many new things have happened, including the emergence of the hegemonic power of China and other events like climate change, like big pandemics like the COVID pandemic. So we need to revisit the rules. If we want to focus specifically on subsidies, again, I particularly like the point made in various ways by Professor Zhu, that subsidy rules, because remember, in the end, what we are talking about, especially with reference to China, and also when we talk about state enterprises, is a subsidy issue. is that the subsidy rules, as of now, are completely silent with respect to the legitimate public policy objectives that one country, whatever country, could have in subsidizing. So this is creating a lot of application difficulties, and clearly this is a point which is put forward by China in its proposal for reform, which I would say is very, very much sound. We would need to address head-on how to regulate, what are good subsidies and how to regulate them. Second point, process matter. Initially, I was very excited when the trilateral US, EU, Japan initiative came out, because I said, okay, great, eventually we start to see a real talk of reform. But then I started to talk with other people and think about it, and I saw two big problems. The big problem is that you cannot start a discussion about issues that are general issues without having engaged other big players, and in particular China. You cannot have a discussion about subsidies and about SOEs, about market distorting practices, whatever they are, if you don't engage positively China, if China is not sitting at the table. So this point is a procedural point. I link that to one point made by Professor Gong. Yes, multilateralism, the WTO should be the way, but I'm wondering if we stick to the consensus principle at the beginning of our journey, will we ever reach anything? So probably it would be more sound to talk about a plurilateral, a genuinely plurilateral discussion with all the big stakeholders, including, of course, China, and see how it goes. And clearly can be an open plurilateral type of discussion, open to other stakeholders. Many scholars like Mavroidis and Bernard Höckman have been discussing about these ideas of a plurilateral initiative to reform the WTO, which is clearly the first step. Ideally, we would need to have a multilateral outcome, but if you immediately put that down, it can be a non-starter. Like say, the only problem we have is China. It's a non-starter, okay? The other point I would like to make is about substantive principles. So it is very much in line of both what was said by both Professor Gong and Professor Zhu. And here I have to immediately disclose that the comment I'm making is not my own. There was recently another very interesting webinar by Simon Evenet, very famous economist, and he was summarizing the points that he made together with Richard Baldwin, another famous economist, in a recent book. And they were saying that the issue is not a market versus a state presence. Yes, the market is everywhere, including in China, and that is recognized also by many non-Chinese observers. But the state intervention is everywhere in Europe, and I also would like to highlight that the EU is a big player in the possible reshaping of the trading rules in the world, but also in the United States. It is a very common held narrative that the US have a market economy. Yes, but that does not mean that there is no state intervention at all. That's against the real world. So the issue is not really politically to say market versus state. It's a matter of degree, but the big issue in any trade negotiation is about addressing the spillovers. If there are no spillovers or no meaningful spillover across the border, there is no problem. China can do whatever they want with their subsidies and with their industrial policies. And the same applies for India, the EU, Brazil, whatever country. It becomes an issue whether the action is in line with the market or not, when there are negative spillovers on other economies. And that should be the focus on trade negotiations, how to regulate spillovers. So the final point I will make linked to that is that saying subsidies, saying industrial policies, saying state intervention in the market, well, this is not blasphemy. They're not essentially or by definition negative words. The problem is when a subsidy, industrial policy, or a state intervention does cause negative spillovers on other economies. And over there is a need to really regulate the spillovers. And in the case of big different systems of the economy, of corporate governance, of capitalism, like the Chinese one or the US or the EU one, is to create interfaces between the various systems. This is not new. Go back to the dear old readings of John Jackson, so very much a GATT period. And one of the issues he was addressing was the issue of creating interfaces between different legal systems. This is probably another important political focus for the negotiation, rather than saying the GATT WTO is about a market economy and you need to stick to this only single model, because there is no one single model. In every economy, you have a mix of market and state. So the issue is really, are there negative spillovers? How we regulate them? How we interface different systems? Clearly, issues of transparency, good governance are always relevant. As Professor Gong mentioned, there are general principles that have to be stick, like non-discrimination. That's fine, and I think everybody would agree with that. But probably there are some buzzwords, like, you know, the problem is China, full stop, or we need to have a market economy, like a pure market economy, full stop. What about public policy objectives? What about policy space? So I think, you know, there is room for negotiations. And the final really element I would like to highlight is that the pandemic is a crisis, but as with any crisis, this can provide opportunities. And new changes in leadership that we have with a new administration coming in a few days, with a new DG, and hopefully will be appointed at the WTO, with the role of the EU that traditionally is a bridge between the different positions that you have in the US and in China, and many other elements and common challenges that need to be sorted out. You could have good ingredients there for the possibility of, at the very least, starting positive discussions for changing the rule book. Thank you very much.
Many thanks, Dr. Rubini, I think, for those very meaningful comments and this emphasis on the need to create an interface between different systems. And I think this very argument of saying that we need to create bridges is very much the kind of idea in the background of this forum, which indeed aims to create such bridges between not only different economic systems, but indeed different legal and political systems. I would like to give the opportunity, to our speakers to respond very briefly, please, to those comments. I'm just aware of the time here, but I just would like to make sure that you get at least 2 or 3 minutes max each to answer those comments by Dr. Rubini. So may I suggest that we start with Professor Gong?
Okay. Yes, I totally agree with Professor's comments about that. That we should be very clear about the WTO reform, not particularly target China. Of course, some issues quite related to China, like subsidies, standalone enterprises. We have in the new rules on that, but we need to negotiation. We should be open the door for the negotiation, not only just like I said, not as a blank game. There's no result, no go forward. And we are quite interested about that, saying that there's no single model in the WTO, or there's no pure market economies. Maybe this could be very arguable issues in WTO members, because some member we think that the fundamental principle of the WTO is some we call the market economics. But you said the pure market economics. What is the pure market economics? Maybe this could arguable. I just stopped here. Thank you.
Many thanks, Professor Gong. Professor Zhao?
Yes, sorry, I was kind of interrupted a bit by my internet. It's normally happened at 10 p.m. at night, and so it was just exactly 10 p.m. So I was interrupted a bit. So I'll try my best. I again totally agree with Professor Rubini and also Professor Gong about that any negotiations going forward, and particularly in the subsidy area, should not target China. And this goes to the trilateral statement, which proposes, the different kinds of subsidies that needs to be prohibited. Now, so to the extent that these proposals are actually focused on China or target China, if you like, there has been no justifications behind why these particular subsidies should be prohibited. And so I guess the problem in the trilateral statement and proposal, it goes beyond the process. It's really in the substance of the proposal itself, has no justification for why we prohibit some types of subsidies without prohibit some other types of subsidies. For example, I don't think they have actually mentioned the subsidies provided to the aviation champions in US and the EU. A dispute has lasted for about 16 or 17 years. So why? The question is. So that's, again, if the justification, the spillover effects, also as Professor Rubini has mentioned in the comments, which is the major point I think has been raised in the international community nowadays about how to deal with subsidies and cross-border effects. My comments on that is that we do also need to consider the political reality about, perhaps back in the home, some of the subsidies that even have the largest spillover effects can't actually be removed for political reasons. So that's precisely why we think that there needs to be an individual approach instead of a general approach about, you could have the general approach to say that everybody agrees these subsidies needs to be prohibited, like we did back in the Uruguay round or the Tokyo round. But now, I think most of the other subsidies that could have spillover effects needs to be regulated in individual schedules that provides the political flexibility for governments to respond to their domestic needs. I'll stop there.
Many thanks, Professor Zhao. I would like now to thank really our two speakers and discussants for what I think was an excellent first session. So really many thanks to the three of you. And it is now my pleasure then to give the floor to my colleague, Dr. Gabriel Gary, for the second session. Thank you, Gabriel.
Thank you, Matthew. Welcome everyone. Good morning and whatever good time you are in. My name is Gabriel Gary. I'm a reader in international economic law at Queen Mary University. And in this session, we are going to address two key issues relating to China and influence of China, multilateral trade and investment governance. One is dispute resolution in the context of the Belt and Road Initiative. And the other one is China's position on digital trade, in particular on the cross-border flow of information. I mean, I was reading, I'm going to be very brief in my introductory remarks in the interest of time, but just remind what I was telling to my colleagues at the beginning, that I read this morning that China's economic growth forecast reached 6.5% in the last quarter. So we're talking about a second economy in the world growing in a context of pandemic. So it's absolutely essential to understand the motivations and the influence of China in multilateral trade and investment governance. And this initiative that bridges top Chinese scholars with non-Chinese audience is absolutely essential, and I'm delighted to be part of this. So without further ado, let me introduce the two speakers. We're going to have one presentation on BRI and dispute resolution that will be presented by Dr. Ming Charlie Fan, who is the Regional Director of Arbitration and Alternative Dispute Resolution for North Asia of the International Chamber of Commerce, International Court Arbitration, and Secretary of the ICC Belt and Road Initiative. He also serves as Chief Representative of ICC Shanghai Representative Office, covering 19 jurisdictions in the region, and he is an arbitrator with vast, extensive arbitration experience. He has served as presiding arbitrator, sole arbitrator, and party-appointed arbitrator in more than 200 cases. Dr. Fan received his PhD from East China University of Political Science and Law and was a Fulbright visiting scholar at Duke University. So we are very well covered in terms of expertise to talk about BRI and dispute resolution. And to address China's position towards digital trade and cross-border flow of information, we have Mr. Zheng Zhang, who is Associate Professor and Assistant Dean at Jiaotong University School of Law. He is the Deputy Secretary General of the China International Investment Arbitration Forum, Director of the Chinese Society of International Law, and editor of the Chinese Journal of Comparative Law. And he mainly focused on international investment law and comparative law, and he has published various articles in refereed journals. And then we have two excellent discussants. So we have two in this session. So more than ever, I will ask presenters to stick to 12-15 minute maximum, so we can give time to our two commentators to make their remarks. So first we have Dr. Naveen Ahuja, postdoctoral researcher from City University of London. He has earned his doctorate in international arbitration, during part of which he was a visiting fellow and subsequently a senior research associate at City University of Hong Kong. And he's an editorial board member of the International Arbitration Law Review, an accredited tribunal secretary and accredited general mediator. We also have the second commentator, which is Dr. Ines Williams, good friend, and she's associate at Sidley Austin, where she assists clients on international trade and investment, and she focuses on issues specifically related to digital trade, including cross-border data flows and digital regulation. Prior to joining Sidley, Ines interned at the appellate body secretariat of the WTO, and she wrote her thesis on the legal framework applicable to digital services at Leuven Center for Global Governance Studies in the University of Leuven in the Netherlands. Her research has been published in leading journals and is in a very well positioned to discuss these presentations as well. So without further ado, I will give the floor to Dr. Ming Charlie Fan to do his presentation.
Okay, thank you very much, Professor Gary. Well, please feel free to interrupt me if I'm exceeding my time limits. And good morning, good afternoon, good evening, audience, my friends. Well, I have to apologize that I probably have to switch off my camera because of the very bad connection, to ensure that my sound, my voice will be convenient conveyed to you. Yes, just a moment. Well, I'm sharing my screen now. Okay. So my topic is BRI and the International Dispute Resolution and the ICC perspective. The contents of this presentation will include what is ICC, ICC-DRS, because I'm speaking from the perspective of ICC instead of the Chinese perspective. Then an overview of the BRI and the BRI commercial disputes. I'm providing some background of the BRI, an example of Myanmar, then the BRI commercial disputes. Finally, I'm going to share with you a little bit of ICC-DRS presence on the Belt and the Road. So what is ICC? ICC, known to many people, an arbitrary institution, but rather ICC is an international organization established in 1919. It has observer's status before the UN Assembly, together with the other two non-governmental organizations, which are International Olympics and International Red Cross. So the other observers are mainly intergovernment organizations. Then ICC is in the position to represent the business community before international organizations, including UN, WTO, G20, and so on and so forth. Then the ICC is also well known for its products, including Incoterms, UCP, certificates of origins, AT Coronet, and so on and so forth. Then for ICC-DRS, ICC doesn't only have ICC arbitration, but also alternative dispute resolution center. This is the structure of the ICC-DRS. It includes the ICC International Court of Arbitration, which is composed of one president, 17 vice presidents, then the 175 members worldwide who conduct weekly committee sessions and monthly plenary sessions to scrutinize arbitral awards before the arbitral awards are issued. Then there is a secretariat assisting the court to administrate cases. Then there is ICC Commission on Arbitration and ADR. It is a kind of a legislative body of ICC to draft, for example, ICC arbitration rules and all kinds of research documents reporting the developments of international arbitration and the dispute resolution. One thing to be noted is that the draft of New York Convention actually was drafted by the ICC Commission of Arbitration and ADR in 1953, which were subsequently provided to the UN for the UN members to sign. Then the ICC International Center for ADR administrates mediation, experts, doc decks, which is the dispute resolution mechanism for documentary credits, including, for example, UCP, URDG, and so on and so forth. So this is pretty much the structure of the ICC-DRS. Then the ICC Secretariat, it is mainly in Paris, apparently. Then it also has 4 overseas offices, first in Hong Kong, then in New York, then Singapore and Brazil. Therefore, ICC is able to provide its arbitration services 24 hours without time difference. In the near future, in March or April, there will be the 5th overseas case management office in Abu Dhabi. Then probably the 6th one, I'm not sure, but we're discussing the possibility to have one in the mainland China. Then the number of cases registered by year. There were only 56 cases in 1970, then increased gradually over the years. Now it is 929 cases last year. And the average amount in dispute in the pending cases is currently 140 million per case, $140 million per case. Then the distribution based on industries. The biggest one is construction and engineering, then energy, then we see transportation, financing, insurance, industry equipments, telecom, and specialized equipment, and so on and so forth. These are very much related to the Belt and Road. I like this one very much because this came from the Queen Mary's report of the Survey of International Arbitration. If I'm not mistaken, it was published in 2018, and it demonstrates that ICC has been a leading arbitral institution worldwide. Then an overview of BRI and BRI commercial disputes, BRI and example of Myanmar. Apparently, we have a lot of BRI countries, so-called BRI countries, but Myanmar is one of the examples that I think would be of interest to many audience because it is very close to China, and it has seen a rapid development over the last years, and it has a lot of potentials. It is very unique. Therefore, I would like to share with you the example of Myanmar. But first, we look at BRI. On the left column, we see the development of BRI over the last 6-7 years. From September 2013, China's President Xi proposed BRI during his visit to Kazakhstan. Then the BRI Vision and Action Plan was released. Then in 2017, the first Belt and Road Forum was convened in Beijing. After that, April 2019, the second Belt and Road Forum was convened in Beijing again. So then if we look at the right column, we see the statistics from the MOFCOM, the Ministry of Commerce of China, providing some figures. I didn't put in all the figures of 2020 because it's very much altered by the fact and the influence of the pandemic. But if we look at the trend before the pandemic, if we want to see the trend of the before the pandemic, we can look at the statistics. The direct investment stable and increasing, contract value of overseas projects stable and increasing. Then the number of contracts of overseas projects increasing, stable, investment countries the same. And then also China's investment in terms of M&A in BRI countries continues to increase as well. Therefore, the BRI has been a long-term project, has been considered a long-term project, and has come up with many projects and transactions already, which after several years we can expect and predict a lot of disputes arising out of these contracts on the Belt and Road. Then we also look at the Myanmar. I'm sorry, the Myanmar. Myanmar has a population of 50 million. It has a substantial land mass and a lengthy and a largely pristine coastline. It benefits from a strategically important location bordering Asia's two giants, China and India. It is richly endowed with natural resources, including oil, natural gas, gemstones, precious metal, jade, and so on and so forth. Then Myanmar is a country of significant potential, but in order to realize its potential, it needs infrastructure of all sorts, including power generation plants, roads, railways, pipelines, deep water ports, and airports. In theory, it has the natural resources to pay for these. For example, the jade trade alone was estimated to be worth up to 31 billion US dollars in 2014. Then from China's perspective, Myanmar is valuable both for these natural resources and because it provides a shortcut from Yunnan province to southern China, in the southern China, to the Bay of Bengal and the Indian Ocean, without the need to travel to the Strait of Malacca and then make the long journey up through the southern China Sea. So there are a lot of potential for the collaboration between the two countries on the Belt and Road. Then there are, if we take but even if there are a lot of potentials and there are a lot of projects underway, we are also seeing some potential difficulties and disputes arising out of these projects. Taking the China-Myanmar economic corridor as an example, the China-Myanmar economic corridor is intended to be the parallel expressway and a railway line, which will run from China's Yunnan province to Mandala in Myanmar, where it will focus southward to Myanmar's commercial capital, Yangon, and the west to Kalkfjord. I'm sorry for the pronunciation. On the 1st of December 2017, President Xi and the State Councillor of Myanmar, Aung San Suu Kyi, reached a preliminary agreement on this proposed mega project. However, the estimated cost of 20 billion US dollars for this railway again raised concerns for Myanmar about a potential debt trap. Then in October 2018, an MOU was signed for a proposed railway line from Myanmar border town of Muse to Mandala. And the proposal for this first phase is that electric train will run at a town of Muse to, will run at speeds of 160 kilometers per hour, which will represent a huge improvement in terms of the connectivity. However, the project could easily provoke more armed conflicts along the route in Myanmar's Shan state, where ethnic armed groups have been battling the military for decades. So the political uncertainty that brought into the business may inevitably lead to the differences in the performance of the contract and potentially need for arbitration in business sector. So this is a very typical example for potential disputes arising out of the collaboration on the Belt and Road. A developing country receiving a lot of funds, investments to do projects, infrastructure projects in the country from China. Then, however, there were rich natural resources and urgent needs for the improvement of infrastructure. These are the common interests that can be the basis of the collaboration. However, on the other hand, there will be a lot of uncertainty in political, in safety, security, and so on and so forth, as well as the potential concerns of debt trap, which eventually will lead to potential differences in the performance and eventually lead to dispute resolution. Therefore, we are predicting a lot of dispute resolution necessity in the years to come after the contracts are signed or signed several years ago. Then
Dr. Fan, sorry to interrupt. I hate to do this, but we're running out of time. So if we can round up as quickly as possible so we have time for the next presenters.
Thank you very much. I will wrap up within 30 seconds, no more than 30 seconds.
Thank you.
Thank you. Yeah. Well, for BRI commercial disputes, the mainland China has tried to establish a lot of infrastructures, legal infrastructures, to provide the services to it, including the Supreme People's Court as a declaration of Nanning Statement, together with the justices of ASEAN countries, to provide enforcement of judgments of based on reciprocal reciprocity basis. Then also CICC, China's International Commercial Courts, as well as the Chinese arbitral institutions. Then also there are a lot of international arbitral institutions ready to provide assistance in this term, including ICC, HKIC, Singapore, LCI, and so on and so forth. And this is a demonstration of ICC's presence on the Belt and the Road for your kind of reference. Then ICC also has its Belt and Road Commission, including a lot of practitioners as well, ready to provide services to parties involved in BRI projects. I'm sorry that I'm running out of time, but thank you very much for your patience.
Thank you very much, Dr. Fan. I mean, the scale of investment involved in the BRI is staggering. And I think the role of the private sector in contributing to disputes resolution in this endeavor through the ICC is quite relevant. I used to think about global economic governance on nation-state initiatives, but here we have the role of private initiatives as well collaborating on dispute resolution. So thank you very much for your presentation on that. And we move to the presentation of Professor Zhang Zhen, Associate Professor, on China's approach to cross-border data flows in international trade agreements. So the floor is yours, Professor Zhang. Hello.
I forgot to open my microphone. And thank you so much for your introduction, Professor Gary. And before my presentation, I wanted to say many thanks to the organizers for this wonderful event. And I'm very happy to sit in together with many distinguished Chinese scholars. And the reason for me to choose this topic is twofold. On the first, the data has become the lifeblood of the digital economy, and it has made more value than trade, than good in global trade. And the second reason for me to choose this topic is because China's position on cross-border data flow, which is Cbdf, is vital in current situation, because there's no currently there's no multilateral agreement on Cbdf, and there are some divided positions, and China is one of the three different positions. And before go to China's approach to Cbdf in international economic law, I wanted to give a very brief introduction to China's domestic law on Cbdf, and then the third part we'll look at the features of China's approach and to discuss how it is different from that of the EU and the US. And in the fourth part, we'll discuss how to bridge the divide, how to help to reach a multilateral consensus on Cbdf. And generally, the China's domestic law and policy on Cbdf can be divided into two phases. And such division is characterized by the adoption of the cybersecurity law in 2016. And before 2016, Chinese law on Cbdf, they are mainly consist of regulations adopted by the State Council and the Department of the State Council. And there's no basic law, and such provisions mainly focus on data localization we have regulations on status secrets, also the regulation on personal financial information, and also regulation on health information. And such regulation mainly requires that all the digital services or all the computer services dealing with such data should be stored in China. And after 2016, which is the adoption of the cybersecurity law, the China's approach on the domestic law approach on Cbdf can be characterized into the following four features. And the first one is different from the phase one, and the law on Cbdf and the digital trade consists of the basic law, which are adopted by the Standing Committee of the National People's Congress or directly by the National People's Congress. And at this stage, there are three pillars of the laws on Cbdf, which consist of the cybersecurity law in 2016, and the other two are only draft. They are not entered into law. They are draft issued by the NPC in 2020. They are the data security law and also the personal information protection law. And at this stage, while China still focuses on data localization, China is considering to move forward to consider to protect the privacy of the personal information. And China also adopted the civil code. And there's one chapter in the civil code to discuss how to protect the privacy, the personal privacy. And in the draft law on personal information protection law, China also committed to participate in international in the negotiations of international agreement to help to shape one to shape the global the international law on the protection of personal information, also to secure the flows of personal and the flows of personal information. So basically, these are the overview of China's domestic law on the on Cbdf. Because of the time limit, I cannot go into the details of the provisions of the of these laws. But there's one article I want to mention is Article 37 of the Cybersecurity Law, and it emphasizes that the data should be stored within China. But if it's necessary to provide such information to overseas parties, there should be some approval first before the transfer. And we also have one case concerning the transfer of data to overseas institutions. So there's one administrative punishment in 2015. In this case, one company in Shenzhen, it has a scientific cooperation with one institute in of Oxford University, but the Shenzhen company did not get approval before it transferred some data about genes to so it is get punished. It get an administrative punishment by the local government. Now I move to the second part, which are WTO, which China's position on WTO negotiations and China's position in free trade agreement. And we all know that the WTO established one working group to discuss the e-commerce issues in 1990s, but China's become active in the negotiation only after 2016. And after that, China become more active in the WTO negotiation. But if we look at the China's proposal, we can also see some difference, because China mainly focus on the promotion and facilitation of cross-border trade in goods enabled by internet. And till now, China doesn't does not submit her proposal on Cbdf. In 2019, China and 75 WTO members released the joint statement on electronic commerce in Davos. And if we look at the website on e-commerce on WTO, we can find that it mentioned that a draft is to be formed by the end of 2020, but until now, we cannot see such kind of draft of consensus. And at the multilateral level, China also encouraged the G20 countries to adopt the G20 Digital Economy Development and Cooperation Initiative in 2016, when China hosted the G20 conference. And in that initiative, China recognized the G20, China and other G20 members recognized the applicable frameworks for privacy and personal data protection, as well as IP rights, and also they are essential to strengthen confidence and trust in the digital economy. At the free trade agreement, China started to refer to digital trade or electronic commerce in 2028 when it signed the FTA with New Zealand, but there's only one mere reference to e-commerce. And China provisions on e-commerce can be found in the FTA between China and South Korea and also the China-Australia free trade agreement. But in these two agreements, there are no concrete provisions on Cbdf. And one breakthrough can be found in the recently signed agreement, the RCEP, the Regional Comprehensive Economic Partnership. And in that treaty, there are two provisions that is closely related to Cbdf, which is Article 2014, location of computer facility, and also Article 2015, cross-border transfer of information by electronic means. But these two provisions are more conservative compared with the provisions on TPP and CPTPP. And based on China's practice at domestic law and international law, four features can be observed. The first one is that China put more focus over the national security and also the national sovereignty, and provisions on such priority can be found in the cybersecurity law and also the two draft. And following the first feature, and the second one is the China's focus on data localization, and it mainly emphasizes that the important data, in particular the important data, should be studied in China. But after 2016, in particular in recent years, we can see China's the development of China's position towards the protection of privacy, and also China's commitment in the WTO negotiations and some other multilateral initiatives to get involved in the shape of the rules, international rules on Cbdf. And the fourth feature, as I mentioned earlier, will be the different positions between the US, EU, and China. For the US, it mainly focuses on the free flows of data, and the EU, it mainly focuses on the which is featured by the GDPR, focus on the privacy, the privacy, because privacy is regarded by the EU as human right, and China, it focuses on the national security and the sovereignty, and it also focuses on the data localization. And so I will try to finish my part in 3 minutes. And in relation to how to bridge the division, I think China can do it through the domestic efforts and also international efforts. For the domestic efforts, China should try to allow the flows of data. But before that, China may implement the data grids and classifications, so which will be helpful to sort out the business data that can be allowed to free flow between different countries. And we can also see the trend in the master plan for the construction of the Hainan Free Trade Port. And the Hainan Free Trade Port is more like the Shanghai Pilot Free Trade Zone. So China can do some test in the Hainan Free Trade Port before such a policy can be expanded nationwide in China. And if you look at the master plan, we can see that there are some provisions on the on Cbdf because there are some provision on facilitated data flows, and also China committed to realize secure and orderly data flows. So this is the domestic effort. And for the in addition to the international efforts, we all know we may know that the President Xi Jinping mentioned that China will actively consider joining the CPTPP. And in the CPTPP, there are some concrete and strong provisions on the cross-border data flows. So then will be helpful for China to catch up with the international best practice. And also the Cbdf can be issues to be addressed in the China's U.S. trade deal phase 2, if any. We know Biden may continue the talk, but unless we need to see. And the final point is that China can make use of its participation in the multilateral negotiations such as the WTO, the G20, and the BRI to promote the shape of the multilateral rules on cross-border data flows. And I wanted to conclude my presentation by one sentence cited from the McKinsey report in 2017. It mentioned that China has the opportunities to lead in each of the areas, and China can help to bring the rest of the world online and lead international efforts to establish frameworks on data standard, cybersecurity, and artificial intelligence. And that's all. Thank you so much.
Thank you very much, Professor Zhang, for your presentation. I think this is very exciting, it's very up to date, and it shows how dynamic is this situation. I mean, we tend to think, oh, China is all about national security. The only thing they want is digital trade for trading goods, and that's all. But here we can see that a very step by step, in a Chinese style, crossing the river stone by stone, so to speak, they are trying to open and commit to multilateral, finding multilateral solutions to this problem. And you say, on the other hand, we see the United States as very much growing concern on national security. So it's not just about one being in favor of national security and the other on free, unfettered free flow of information. So this is very dynamic, very useful, and we have to keep a close eye on this development. Thank you so much for that. So I give the floor now. We have two commentators, so I will ask them to be a little bit more brief. Let's start with Dr. Naveen Ahuja. I can see you there. Please go ahead if you're ready.
Thank you. I'll try to be as brief as possible. Yeah. I first want to thank the organizers for this opportunity. I'll start with Dr. Fan Ming Chao's presentation, which was insightful. As he suggested, there are various choices available to the parties for resolving their BRI-related disputes. I'll discuss two angles which weren't actually discussed here, some of it. From the procedural angle, first, Dr. Fan mentioned that China has attempted to set up mechanisms to deal with BRI-related disputes. For example, in 2018, the Supreme People's Court in China created two branches of an international commercial court in Shenzhen and Xi'an that act as both the first instant court as well as the final court. And of course, the mission of the court was to resolve all international commercial disputes, particularly the BRI-related disputes. Second, parties may also prefer mediation, particularly with the new Singapore Mediation Convention in force. Attempting to resolve a dispute via mediation is usually quick and cost efficient. Although approximately 70% of the disputes are generally resolved. Nonetheless, a party cannot be compelled to attend a mediation, or rather the mediation process cannot proceed in the absence of one of the parties. Therefore, a hybrid or a multi-tiered dispute resolution clause might be preferable, which may provide, for example, mediation being the first step, failing which a party may commence arbitration. And that being because arbitration can proceed regardless of whether or not a party chooses to participate, so long as a non-participating party has been notified. I believe ICC recognizes and supports the use of mediation as a prerequisite to arbitration, which is referred to as med-arb. Third, and perhaps the most ideal, might be international arbitration, as Dr. Fan has mentioned. As it is a platform where participants from different legal and cultural backgrounds meet. In addition to the parties being able to choose their decision maker, as well as the number of decision makers, i.e. the arbitrators, there is the neutral venue factor. So in cross-border activities, parties may wish to avoid having to submit to the jurisdiction of the courts of one of the parties. It's a question of leverage, in some cases unfamiliarity, or a lack of trust of the judicial system of that other party. Then there's the confidentiality factor. Some parties may worry that their reputation might be affected if proceedings became public, or even if their fact became public. Or certain parties would not want their trade secrets disclosed outside the confines of the arbitration proceedings. Third one is the enforcement factor. Of course, one of the key features of international arbitration is that arbitral awards can be enforced internationally through New York Convention. By adopting the New York Convention, these member states have undertaken to enforce arbitral awards as though they were final judgments of their own highest courts. And the last one would be the finality factor. There are more than this, but I'm just addressing a few factors. The finality factor. An arbitral award is generally final and binding. Setting aside is an exclusive recourse against an arbitral award by applying to the court of the seat. And it's limited to challenges on procedural grounds only. That said, there are certain applicable laws, such as the English Arbitration Act or the New Zealand Arbitration Act, which permit parties to lodge a limited appeal against an arbitral award on a point of law. In fact, even certain arbitration rules allow for an appeal and review mechanism. At the other end of the spectrum, some arbitration rules go as far as waiving the party's right to any form of recourse. Now, that's from the procedural angle. From the substantive law angle, given that there might exist multiple contracts, and if a dispute concerns, for example, a sale of goods, in such case, the CISG, which is the United Nations Convention on Contracts for the International Sale of Goods, might be preferable, as it consists of, along other things, common law elements as well as civil law ideas, which is an ideal hybrid. Alternatively, if there's no sale of goods, perhaps parties might prefer the Wto Principles of international commercial contracts to be applicable. The Wto Principles contains numerous CISG ideas and brought them to general contract law level, as they're not intended to regulate sales law only. Now, Professor Jan Cheng's presentation was stimulating. Just taking a step back,
Dr. Navin, sorry to interrupt you. If you, in the interest of time, if you can be very quick with respect to the reactions to Professor Zhang. Sorry about that.
Certainly. Professor Zhang mentioned some free trade agreements which refer to e-commerce and so on, but in certain IIAs which don't refer to such exceptions and or do not address e-commerce and just look at the word investment, then we'd have to look at the Salini criteria to determine whether it constitutes an investment, and also the fact that there's no actual operations in the host state. So the person, the investor, could be seen as a trader rather than an investor. Thank you.
Thank you. Thank you very much. Ines, the floor is yours. Unmute yourself, please.
Does this work better?
Yeah. Yes,
okay.
That works. Thank you.
Hi, Gabriel. First of all, thank you for inviting me. These were two very interesting presentations. I'll limit my comments to Professor Zhang's presentation because that's where my expertise lies. So first of all, thank you for elaborating on China's position, on indicating the evolutions in its domestic law and policies, because for foreign lawyers, it's often very difficult to get a clear view of what is happening at a domestic level in China. So I think that was very enlightening. Also to see that since 2016, things have changed with the cybersecurity law, but also that there's new rules in the pipeline, especially when it comes to privacy protection, which might help China move a bit closer to the EU data realm and what the EU considers important in regulating data. When it comes to the multilateral initiatives, I think China, as one of the 3 data realms, has a very important role to play. And I do hope that China is taking a very proactive approach in the ongoing negotiations, because as you said, they had predicted, or they had wanted to achieve a consolidated text by the end of the year, which hasn't happened yet. So it remains to be seen how close the parties can get to agreement. When it comes to the third element that you discussed, so the FTAs, from my research, I also looked quite a bit into e-commerce provisions in various existing free trade agreements, and there, indeed, it's quite obvious that for China, the provisions on electronic commerce, but on data flows, on data localization requirements are so far very limited. And as you mentioned on your slide, we've seen an important breakthrough with the RCEP that was recently concluded, which included a data localization requirement provision. However, that provision also included a very broad exception that allowed data localization requirements that are necessary to achieve a legitimate public policy objective, which is, I mean, this is a term that's, or a sentence that's very often included, but in RCEP, the parties themselves decide on the level of necessity. So this actually leaves a very broad scope for exception. So it remains to be seen how forceful the data localization requirement provision is. The US-China trade deal that you also mentioned, the phase 2, would be, I mean, it seems like that would be a very important evolution in China's position on the regulation of data flows in free trade agreements. Because if 2 of the 3 data realms, as we call them, are able to agree on provisions on how to manage data flows, I mean, the bar would effectively be set for the rest of the world, or at least highly likely facilitate negotiations also at the multilateral level. I was also, I mean, this was not discussed. No, first another point on free trade agreements, because this was mentioned in the paper that I was sent, that was written by you, which is a very, very interesting paper, which also refers to this new concept of digital trade agreements, so where countries agree on provisions related to digital trade, which have led to quite deep e-commerce commitments. But these agreements also, of course, raise the questions on their consistency with the WTO exceptions for regional trade agreements, which require to cover practically all trade, which is not the case when you're simply concluding an agreement that only covers digital trade. 2 final points I wanted to mention that were not discussed in the presentation, but that were in the paper that you wrote on the protection of cross-border data flows in investment law. I thought it was very interesting to look at it from an investment law perspective, because you're effectively looking at it from a GATS Mode 3 perspective rather than a GATS Mode 1 perspective, which is a more conservative approach to looking at data flows. And there I was wondering how to conceptualize data localization requirements from an investment law perspective. Because a data localization requirement is a requirement to localize data. In some instances, this means a requirement of local presence. So does that then require physical presence in the territory, and thereby requiring investment in the sense of the BITs, but also Mod 3 of the GATS? So I thought that was a very interesting way of looking at it, and I'll leave it at that. Thank you very much.
Thank you very much, Ines. And in the interest of time, I mean, we have only 1 hour left, so I'm going to be a little bit brutal in the summary of these reactions, and give you both of you couple of minutes, not more than a couple of minutes to react. So let's start with Dr. Zhang, and on the comments of Ines, I would highlight, in the interest of time, looking forward, do you see any possibility of reaching agreement between the US and China on cross-border flow? How do you see that coming forward, looking into the future?
Thank you so much for these challenging questions. My answer, my direct answer is that I'm not sure, because there's still some uncertainties on burdens on the new president's policy, whether it will continue the policy by Trump, or whether it will change her position. But anyway, the digital trade, any issues relating to digital trade, such as the Cbdf and also the data localization, will be one area of negotiation between China and the US. Not only on the bilateral level, but also at the WTO level, if it is restored by the US. But I cannot see that China's position will be changed by the US, but there may be some compromise, as mentioned by Professor Gong in his presentation. If there's some compromise between China and the US, then we'll provide some template for other countries to consider the future rules on the digital trade and also on cross-border data flows. And also, I really appreciated the comment from the arena, and so I apologize for my very bad pronunciation of the foreigner's name. For the two commentators, which provide a very crucial point on the relationship between the IIA and the data localization, and also the definition of foreign investment. And because of a time limit, perhaps we can continue our discussion after the meeting. Maybe we can.
Yes. That's very helpful. Really appreciate that. And last but not least, I mean, Dr. Ahuja made a broad range of proposals, alternatives on alternative dispute resolution mechanisms. A very brief reaction to that, Dr. Fan.
Yes, I appreciate that question, as well as the very intelligent recommendations of Dr. Ahuja. That actually covered all the gaps that I would like to fill in during the presentation. And also, very importantly, it's filling all the gaps that private dispute resolution mechanisms need to facilitate the needs and the demands in the market. That's exactly what we are going to do. Thank you very much.
Thank you very much. And I pass the floor without further ado to our third panel. So Dr. Jiang Qing-Jung, the floor is yours. Thank you.
Hi, I'm here, okay. Good evening here in China, okay. We have, in session 3, we have 2 speakers. First is Professor Chen Weidong from University of International Business and Economics. And the second is Professor Chi Man Jiao, also from the same university. And Professor Chen will have a topic on legal response to excessive trade restrictions in the context of post-pandemic. The second topic by Professor Chi will be on the negotiation of an investment facilitation framework for development in the WTO. I think both of the topics are quite interesting, especially on the negotiation. We have fisheries, e-commerce, and also investment facilitation by WTO. And then we will have a comment by Mr. Abdel Hamid Mandou, former director of WTO Trade in Services and Investment Division, senior counsel in King and Spading LLP. So first we will invite Professor Chen Weidong to have the topic on legal response to excessive trade restrictions in the context of DEIC. Okay, so Professor Chen.
Thank you, Professor Zhang. Can you hear me? Hello.
Yes.
Hello, my dear colleagues. It's my pleasure to share my research on the legal response to the trade restrictions in the context of FIC. That means the public health emergency of international concern. That situation usually would be announced by the WHO. So these terms could call a situation such as all of us facing, that is COVID-19. I had to prepare a paper and a brief PPT. So let me share my PPT on the screen. Okay, could you see the PPT now?
Yes.
Could you? Okay, thank you. Okay, as we know, the spread of the excessive trade restrictions during the COVID-19 highlights the failure of the WHO and international health regulations to effectively prevent the restriction and the failure of countries that imposed restrictions to comply with their commitments to multilateral cooperation under the WHO. Could the country resort to the enforcement mechanism under the WIHR, including the dispute settlement mechanism, to safeguard its rights and benefits? If the existing AHR mechanism is weak and unrenewable, is it feasible under the rules of the WTO to protect the rights of countries which suffered from the trade restrictions? Which loopholes exist in the AHR system for the purpose of effective preventing trade restrictions and maintaining global public health security? And how could these loopholes be improved? My presentation want to discuss the above and put forward some policy suggestions. And I will firstly I will introduce the IHR's regulation on restrictive trade measures of the state parties. Especially, I will introduce the Article 43 of the IHR. While this article allows state parties to take measures that exceed temporary recommendations, it set more stringent substantive and procedural conditions for additional measures. This provision says clearly that these regions shall not preclude state parties from implementing health measures in accordance with their relevant national law and obligations under international law in response to specific public health risks or public health emergencies of international concern. However, these measures should be conformed to the following substantive conditions based on necessity and scientificity. The legality of specific measures must be reviewed case by case based on IHR provision. It is worth to note that from a trade interpretation perspective, once a trade restrictive measure was sued, this measure was not complete indefensible. Owing to the lack of relevant dispute settlement practice and the case law, it remains seen whether the claims based on Article 43 can be fully adopted. Moreover, from an international relations perspective, if these measures are found to be illegal, it would mean that almost every country had to sink into the endless challenges against their response measures. The unforeseeable outcome of this dispute and the complexity of cross-border control of COVID-19 make it necessary to consider the solution more comprehensively rather than rely only on legal rules. And then we can discuss functions in the IHR enforcement mechanism. If the states parties seek the WHO to deal with restrictive measures, they would face the problem of dysfunction of the assessment mechanism and the dispute settlement mechanism. First, the assessment mechanism is symbolic. Second, the dispute settlement mechanism under IHR is virtually useless. The IHR has set up two types of dispute settlement mechanism for trade restriction. The special dispute settlement mechanism under Article 3 and the general dispute settlement mechanism under Article 56. The former means that state parties impacted by the measures may request a consultation with the restriction country. The purpose of this consultation is to clarify the scientific information and public health rationale underlying the measures and to find a mutually acceptable solution. This mechanism is limited to consultation. one of the political measures of international dispute settlement and do not provide legal measures or other political measures. The requirements directly from the restricted country to consult with the restricting country may impose diplomatic pressure on the latter, therefore could contribute to ease or lift trade restriction, then resolving the issue quickly and effectively. However, the effectiveness of this approach is also controlled by the fact that governments are too busy coping with domestic outbreaks to initiate consultations. Moreover, since consultations have non-timeline, the restricted country would be helpless if the restricting country willfully delay consultation to prevent an effective resolution. And then, how about the WTO? In my opinion, WTO also is limited to deal with the trade restriction in context of COVID-19. We could classify the trade restrictions into 4 categories. First is export control on certain medical goods and foodstuffs. We can see the export control on medical goods could be challenged on basis of Article 11 of GATT, which concerns the obligation prohibiting quantitative restrictions. The restricting party has 3 options as its defense. The first one is temporary export prohibition or restriction under Article 11.2, a subparagraph. And the second is public health exception under Article 20.b of GATT. The third is the security exception in Article 21. And in my opinion, the defense under Article 11 the conditions contained in Article 11.2, a subparagraph, are very likely consistent with the situation that countries adopt export restrictions in order to meet the domestic demand in the context of COVID-19. It is worth to note that this provision provides the exemption is exclusively to export members. Moreover, the phrase of to prevent or relieve identify the purpose of the export restriction instead of actual or real link between purpose and means. Therefore, the defense under this provision could avert from the burden of proving the measure in consume, satisfying the necessity test and the sharple of the Article 20 of GATT. So it is easy to prove the prove successfully under Article 11.2 a subparagraph. Then the defense under Article 20b. And but we can see the WTO is limited to deal with the restriction. The WTO has called on members to abide by notification obligation and improve transparency on any trade-related measures taken in response to COVID-19. However, even if the obligations of notification and transparency are properly observed, it would not substantially improve the situation that export control measures are widely used and affect the global supply chain of essential goods. And the current WTO dispute settlement mechanism hardly plays a role in solving the problem of the trade restrictions. Let me see. The procedure of WTO dispute settlement consists of several stages, such as consultation and panel review. It usually takes at least 2 years to complete the panel review, which makes it almost impossible to achieve effective relief, which was needed very urgent in the context of COVID-19. In light of the disputes would unavoidably involve with complicated review when the respondent member invoked the exception clause. The process of the dispute settlement will undoubtedly be delayed further. Moreover, the rulings of the WTO are not retroactive. This means the complaining party cannot claim compensations for loss due to the measure taken, regardless whether or not the respondent party withdraw the measures in issue. Lastly, as we know, the appellate body of the WTO had dumped into a situation of paralysis after December 2019 due to the consistent blockage of the election by Trump administration. If the respondent party deliberated appeal the case, even if the panel found that the measures is inconsistent with certain WTO rules, the case would not have any effective solution. So, finally, I want to suggest some possible improvement to preventing excessive trade restrictions. My suggestion is first, Article 43.2 of IHR could be modified to reflect the real and situation. My suggestion is could you hear me? Miss Zhang, could you hear me?
Yes, we can hear you.
Okay,
yes.
okay. Okay, thank you. So my suggestion is as follows. First, where PIAC occurs, a member state may adopt or maintain necessary restriction on international traffic in order to safeguard public health security. Second, restriction on international traffic and trade shall not result in discrimination between state parties and should not exceed the limits necessary to deal with the spread of the pandemic, and in particular, avoid unnecessary damage to the commercial, economic, and financial interest of any other member states. Such restrictions shall be temporary and shall be phased out as the pandemic case and shall be removed as recommended by the WHO. Third, in determining the scope or effects of restriction on international traffic and trade, members may prioritize measures that are more important to preventing the spread of the infectious disease. These restrictions should not be applied or maintained to prevent the supply of medical protective equipment to the effective country. First, the information of any restrictions on international traffic and trade, as well as their scientific evidence and justification shall be promptly submitted to the Director General of the WHO and circulated to all state parties. And second, I also proposed a provision on rapid dispute settlement mechanism. The state party imposed restriction shall promptly consult the state party affected, or the Director General of the WHO shall act as good office with respect to restrictions adopted under this article. And if the consultation, once the party fail to reach an agreement on the matter, the consultation within the stipulated timeline, each party may submit the dispute measures for attribution. The arbitral tribunal shall consist of 3 members appointed by the parties, selected from the list of arbitrators or the existing members of the emergency committee or expert committee. If the party fails to agree on the selection of attributors, the Director General of the WHO shall make the appointment. So that means a dispute settlement that take the model of the WTO dispute settlement. And the arbitrator tribunal shall be composed within 15 working days from the date on which the claim is raised, and the award shall be rendered within 30 days from the said date. The arbitral award shall be final and binding upon the parties, and the parties shall abide by the award. If the party refuse to enforce the award, the other party shall be entitled to adopt retaliatory measures. So, and my conclusion, trade restrictive measures disrupt the supply chains, depress production, and prolong and exacerbate the health and economic crisis.
Professor Chen,
okay.
Can you make very briefly on the conclusion? Okay.
Okay, I will finish my presentation at 30 seconds. Thank you. And fortunately, some countries and intergovernmental organizations have taken some actions. As we know, for example, in March 2020, Germany, France, and the European Commission negotiated an end to inter-European restriction on medical supplies. But a number of the trade restrictions. So if the country repeat the restrictive patterns, they might hinder the efficient production and equitable distribution of the vaccine against the COVID-19. So countries might impose export control on supplies and the inputs necessary for the production of vaccines or on the vaccines themselves. Such actions would likely have a severe impact on the availability of the vaccines in low-income countries in particular. So my conclusion is COVID-19 pandemic should not be an excuse for anti-globalization. International law can truly play an effective role in dealing with pandemics, but only when it becomes a legal mechanism of cooperation. Thank you.
Okay, thank you, Professor Chen. I have a very good topic on the legal response on COVID-19 regarding the trade restrictions, either by proposing a mechanism to solve the possible dispute. So to save the time, we will go to the next topic by Professor Chi Manjiao. Okay, and Professor Chi will have a topic on trade and investment facilitation framework for development in the WTO. So welcome, Professor Chi. Professor Chi Manjiao, do you hear me?
Yes, thank you. Can you hear me?
Yes, yes, clear,
Great.
yes.
Great, thank you very much. First of all, let me start by thanking the organizers for inviting me to this meeting, which I think is very timely and important. So the topic I'm going to focus on is a little bit different from the rest of the panelists in the sense that I would think it's not about China. It's more about international level. But of course, I would be very happy to discuss any situation with regard to China or involving China if any one of you have any interest in that. So the topic is about the negotiation of an agreement in the WTO that is on investment facilitation for development. We can also call it as IFF4D. So I have about 10 minutes. I try to make it very short, given the limit of time. Very few discussions have been dedicated to the issue of investment facilitation in the past years. Mainly, I believe is because at the global level, efforts for making a multilateral investment agreement has not been very successful. We see that from the experiences of OECD. We see that from the experiences of some other platforms. We also see that in the WTO. By more than 20 years ago in the Singapore issues, investment agreement would have been one of these agreements to be negotiated. However, that was dropped because it was very difficult for the WTO members to agree on a set of rules that would be applicable to almost all the countries in the world with regard to investment regulation. In WTO, it has failed. In other fora, it was not really lucky. But over time, countries have been thinking of making an agreement on investment, but this time people thinking about making a narrower focused agreement, and that is investment facilitation. So starting from 2017, the investment facilitation discussions have been kicked off in a lot of forums, notably in the WTO ministerial conferences in Buenos Aires. And then in G20, leading economies in the world have also discussed the issue of investment facilitation. Since last year, by September the 25th, the agreement or the negotiation for an agreement on investment facilitation for sustainable development has been formally kicked off in the WTO. So that marked a very important milestone in the WTO with regard to a negotiation, but also with regard to rulemaking at the global level on investment regulation. This agreement is quite different from other agreements in the WTO. And it is also very different from the existing investment agreements at the global level. And first of all, this agreement, unlike other WTO agreements, this agreement is driven by developing countries, especially Brazil, China, and some Latin American countries. I was in the WTO for a consultation meeting on this agreement, and you see Latin American countries, Brazil, Chile, and also China are quite active in driving this this agreement. The current status is shown in the WTO website, seems to suggest that there are about 106 countries or WTO members now are involved in the negotiation of this agreement. In the future, it is possible that more countries will get involved. And another distinct feature of this agreement is from international investment law perspective. As we all know, international investment law composed mainly of bilateral investment treaties, which is highly decentralized, highly fragmented. So the bilateral agreement system makes it very difficult for countries to negotiate at multilateral level. So the rulemaking paradigm of this agreement, investment facilitation agreement, is quite unique. As I've mentioned, first of all, within the WTO umbrella, it is driven by developing countries, which would bring about very different dynamics from a political economic perspective. And on the other hand, from an economic law perspective, the rulemaking paradigm is also different because it's I wouldn't say the very first time, but it's one of the few efforts at the multilateral level that countries are trying to negotiate a multilateral agreement on investment instead of a regional or mostly bilateral agreement. And the importance of this agreement would not be exaggerated in this very special period of time, as a number of speakers have already mentioned, the WTO and the multilateral trading system is now in crisis. So the potential, if this agreement is successful in the near future, that would be something very, very helpful for the rejuvenation of the WTO and the multilateral trading system. That said, I would just simply use in the next 5 minutes to highlight a few issues that I believe the negotiation of this unprecedented agreement would have to be taken into consideration. And I try to summarize these issues into two aspects. And the first aspect is the relationship between this potential agreement with other WTO agreements. As I've mentioned, WTO hosts quite a number of agreements and different forms of agreement. With regard to this relationship, it could be said as formal relationship, discussing in what form the investment facilitation agreement would be. Would that be an agreement that would be applicable to all WTO members without the possibility of reservation? And the disputes will have to be submitted to WTO dispute settlement, which obviously is now in crisis. Or, as some of the members have proposed, will this agreement be made into a plurilateral agreement, mainly referring to the situation that only those countries are interested will be negotiating and joining? So at this point of time, I would say there is no clear signal what kind of agreement this IFF4D will be, but hopefully this would be a multilateral agreement. So that will be the most ideal result. But of course, if that is the case, then that brings me to my next issue, inquiring the substantive relationship between this agreement and other WTO agreements or under the WTO umbrella. So the most important thing is about the overlap or subject matter overlap between this potential investment facilitation agreement and the existing WTO agreements. And the issue of overlap is often said as nexus or linkages or connections. It has been discussed in various scenarios in WTO rulemaking and WTO dispute settlement. But here, the overlap or nexus would be even more profound. If you consider that a number of WTO agreements now actually contain rules with regard to investment regulation, and some of these rules may be connected with the different forms of investment facilitation measures. For example, if you refer to a technical barrier, it is possible to argue that a certain kind of investment facilitation measure taken by a member state would constitute a technical barrier to international trade, and that would fall into the realm of TBT. That is another WTO agreement. So that would be the substantive issue, and the substantive overlap would be, I would say, would be even more profound if you consider the fact that the international community, including the WTO members, still do not have a clear-cut definition, and probably I doubt they will never have one, clear-cut definition with regard to investment facilitation. So what is investment facilitation remains a undefined or inaccurately defined a concept, at least the legal concept in not only the WTO law, but also investment law. So another part of the relationship is probably more important, is about the relationship between this investment facilitation agreement under the WTO umbrella and the existing over 3,000 bilateral investment treaties and regional trade agreements, investment chapters. As I've mentioned, the subject matter overlap between the potential investment facilitation agreement and existing BITs or IIAs could be very profound. As I've mentioned, for example, transparency. Transparency is now incorporated as a measure into most of the investment treaties, BITs, investment chapters of FTAs. It is penetrating into other treaties as well. It is, of course, will be included into the investment facilitation agreement under the WTO that is negotiating now. If you have a look at the proposed text, consolidated text, and you find transparency is a very important part, and I would think that this transparency part or section would remain largely unchanged in the final draft. So that would be a very important signal. And the signal is that an obligation under the WTO agreement, that's the investment facilitation agreement, is also covered by a bilateral investment treaty. That would bring about a very, very profound challenge to many countries and international community, and that is how to insulate the potential disputes with regard to investment facilitation from roving from WTO to investment state arbitration or investment arbitration. In other words, how to prevent a violation or potential violation of an WTO agreement from being submitted to investment arbitration. This challenge would be especially complicated if we consider the very fact that investment arbitration is highly privatized and decentralized, and then it is also under discussion of reform nowadays. So it is unclear at this point of time how the member states of the WTO will deal with this issue, and then the challenge would remain. And I personally think the challenge would never be satisfactorily settled because it is almost impossible to revise the existing over 3,000 BITs as they are highly decentralized. So the relationship or the integration issue and then the installation issue would remain a profound challenge to WTO members in the negotiation of an investment facilitation agreement. So the future, I'm not sure at this point of time. I was consulting ITC, and I wrote a report for ITC, which is now ready for download on the ITC website. But I personally would think that it is probably too early for anyone to give a clear answer to that. And with that, I would suggest all of us to wait and see how and whether or not and how WTO members would negotiate in an investment facilitation agreement, hopefully in the next few years. So with that, I conclude my presentation. Thank you very much, and I look forward to discussions.
Okay, thank you very much, Professor Chi. Have a very good topic on investment facilitation. It's importance, it's a challenge ahead. And now we invite Mr. Abdel Hamid Mandu to have a comment on both of the speakers.
Well, thank you very much for inviting me. And I've been listening to wonderful presentations, and I will make my comments strictly within the allocated time because I know we're running out of time now, but I would very quickly address the two issues that were raised. The first with respect to trade restrictions in relation to health emergencies and the pandemic. And there, from a trade perspective, I would only just congratulate the speaker for the presentation, but would want to make two comments, actually, highlight 2 points. First is that when we look at the trade rules, we should also not just look at merchandise trade, but look at services trade. Because the trade restrictions that we have seen were not just in the form of export restrictions on certain products, but also affected exports of services. As we know that all services sectors that involve the movement of natural persons, people traveling, were affected. And there were restrictions also imposed on the supply of such services by importing, and I put importing here in inverted commas because, as you know, the definition of trade and services is not just about cross-border movement of products, but also cross-border movement of producers. And of course, the WTO provides exceptions, not just in Article 14, in Article 20 GATT, but also in Article 14 GATS. And those exceptions represent the kind of overriding importance of those policy objectives, whereby members are allowed to deviate from their legal obligations. And the question here becomes one of looking at those exceptions and applying them in a very rigorous way. And I think here the presidency of the Kingdom of Saudi Arabia to the G20 has produced a nice set of guidelines that WTO members should abide by in terms of strictly applying those exceptions and imposing those restrictions only to the extent necessary. And here, let me just clarify from a legal perspective for legal experts. The necessity test is a very interesting legal concept, and it has been subject to some interpretations, which in my view created some confusions. But the necessity test, if applied and interpreted properly, could provide a very, very effective way of determining whether a measure is appropriately imposed or not. A necessity test does not actually test the objective. The objective is yours. It's subject to regulatory sovereignty. Nobody interferes with it at all. The necessity test applies to the measure. And it examines A, the contribution that the measure makes to serving the objective, B, whether that measure can actually be replaced by another measure which produces the same result exactly, but is less trade restrictive and reasonably available to the regulator. If that is proven, then the measure is not necessary. If we take that benchmark in a simple way like this and apply it to the measures that have been applied, we can see what measures are necessary and therefore should enjoy the coverage of exceptions and what should not. And some of those elements actually were expressed in the G20 statements last year in relation to that subject. Now, moving on quickly to what was said about investment facilitation. The investment facilitation process in the WTO is a very interesting process, and I had actually the honor and the privilege to be there at the birth of that process. Because I remember when I was in the WTO, I had the task of presenting to the G20 under the Chinese presidency a paper about policy coherence, trade and investment policy coherence. The birth of that project was basically about how do we achieve trade and investment policy coherence. Why? Because actually the WTO does not just, as I said, apply only to merchandise trade. It applies to trade and services, and trade and services in terms of how trade and services is defined to cover cross-border factor mobility, also covers investment in services. It covers FDI, not investment in general, but FDI in services. And as a matter of fact, in today's world, 2/3 of global FDI flows and global FDI stock is in services sectors. And all that is covered by the MFN obligation in the GATS. And it's covered by national treatment in the GATS, where commitments on national treatment are undertaken, and consequently covered by all disciplines in the GATS as well. So we're starting from a point not only of an interface between trade policy and investment policy as we used to, because when we talk about global value chains, we say, oh, trade and investment policy coherence is very important because this is the backbone, the policy backbone of how global value chains operate. But here, the matter is much deeper, and it's a question of legal consistency and policy coherence as well, that we have an overlap. There is a portion of global FDI, which is 2/3, that is considered by the WTO to be trade. So the discussion of achieving policy coherence under the G20 actually led to the beginning of this dialogue on investment facilitation in the WTO. And at the time we said, okay, let's start, because everybody was thinking about the Singapore issues and all the history about how difficult it is to deal with investment in the WTO. We said, all right, let's start first with the less controversial issues, which would be facilitation. And we took facilitation to mean mainly two things: transparency and facilitating administrative procedures. It's not about what I used to call then at the time the red meat issues about investment treaties, which is market access, investment protection, ISDS, and all the sort of toolkit of legal instruments that are associated with it. Let's start with this. And we started with this actually realizing also that there's a huge overlap between this investment facilitation agenda and the agenda of domestic regulation on services, which is currently under discussion in another joint statement initiative that covers a very similar set of issues. Now, of course, there are differences on the margins, but the point I'm making here is that the policy direction is exactly the same. And it's about achieving systemic coherence. Now, I like very much what the last speaker has sort of summarized and identified, which is mainly the issue of integration and insulation of the investment facilitation framework for development. In terms of integration, I think there is going to be a challenge. We always talk about plurilateral and multilateral. I think we need to clarify here what is meant by plurilateral, because in terms of the usage of the term itself, at least from a legal perspective, I would distinguish between processes and outcomes. There are plurilateral processes that are open, but involve by definition a subset of the membership. But the outcome is applied on MFN basis. And that's what I would call a multilateral outcome. A multilateral outcome, by the way, does not necessarily, at least in WTO history and practices and legal structure, a multilateral process does not necessarily bind all members. It means that it's open to all members and all members benefit from the outcome. It's like the ITA and tariff reductions, they apply on MFN basis. And even those countries and those members who have not signed the ITA would benefit from those tariff reductions. So I would distinguish when it comes to plurilaterals between processes and outcomes. It is, as a matter of fact, a plurilateral process. Now the outcome, I would see it as a multilateral outcome because you cannot actually apply those rules in your investment regime and facilitate investment for some and not facilitate for others. In other words, if it is only about transparency and simplification of procedures, I find it very difficult that any government would apply that on a discriminatory basis. And why would you want to do anyway? But that's my presumption. There are some details on this particular matter to unpack, such as questions of risk of free riders and critical mass and all this, but we don't have the time to get into that now. But I would say that the assumption would be that the outcome would be applied on MFN basis. In terms of insulation, which I think is a very, very good point, insulation, yes, you can insulate the investment framework from other agreements. In other words, negotiators could have legal provisions which would mean that whatever is committed here is not affected by what is committed elsewhere. And this is not going to be the first time that we have legal provisions of that sort. If you look at Article 2 of the TRIPS agreement, for example, which determines the relationship between the TRIPS agreement and intellectual property conventions, it is, of course, determined in the other way, but you can also reverse the same logic of the provision and say, well, this framework is not affected by any obligations negotiated under other frameworks. But you cannot do that in the WTO in the opposite direction. In other words, you cannot say that obligations under other agreements will not be affected by this. This is not to say, by the way, and this is a very important legal distinction in my view, this is not to say that that an ISDS case would enforce the provisions of the framework. No, an ISDS case would be given rise to based on the measures that a certain government would take, perhaps pursuant to obligations under the framework. But it's not going to be by way of importing a provision of the investment facilitation framework into an ISDS process and then start interpreting a WTO provision in that process. It is only going to look at the measure that a government has taken pursuant to an obligation in the WTO and see how that measure is consistent or otherwise with the obligations under a bilateral investment treaty or otherwise. So it is important to look at this insulation issue with some kind of legal hierarchy. I'm sorry I've exceeded the 10 minutes that I intended to take, but back to you, and thank you very much for this opportunity to make these comments.
Thank you very much. We have a very good comment. Due to the time limit, we cannot hear much more from you, but I think it's very interesting comment on both of the speakers. To save time, I want to pass this to our last speaker, the closing remark by Professor Ying, Peter Ying. Are you available now?
Yes, can you hear me? Yes. So, dear all participants, good afternoon and also good evening. I'm Peter from Shanghai University of International Business and Economics. It's my pleasure to make a brief closing remark on today's seminar. It is a pity that the meeting is drawing to a close, although everyone is still in the mood. First of all, please allow me to thank all the participants in today's meeting, especially the speakers, moderators, and the discussants, as well as the organizers, among which Professor Malik from Queen Mary University of London and Dr. Zhang Jiao from East China University of Political Science Law have made a particularly important contribution. The idea to launch a webinar focusing on China's role in international law and international trade and investment law was initiated only about 2 months ago. So we had only very limited time to prepare. In the case that everyone's work and life are greatly affected by the pandemic lockdown, the successful organization of this conference was not easy and could not be separated from efforts of all sides. Thank you all. And despite the short time to prepare, the outcomes of today's meeting, I think, are fruitful. We discussed hot topics related to WTO reform, Belt and Road initiatives, as well as trade and investment negotiations under China's perspective. And the agenda is very novel. Experts from China are particularly familiar with Chinese issues, give keynote speeches on hot issues, and then experts from Europe comment. I'm not willing to repeat their fantastic speeches, but the exchange and the collision of the thinking definitely lays a foundation and a rational knowledge for all to enhance understanding and further cooperation. Well, as Professor Malik has introduced at the beginning, the School of Trade Negotiations of SWIBI is one of the 19 WTO chairs institutes selected by the WTO in China. And after fierce competition, it also became a new WTO partner institution for regional trade policy course in the Asia and Pacific region last year. So during the next 4 years, we will hold intensive trade policy training for trade policy officers from 30 WTO members and observers in the Asia and Pacific region. So this will definitely help deepen the exchange and cooperation between China and other economies covered by the Belt and Road Initiative. Sincerely, I hope our exploration in coming years can be supported by all participants of today's webinar. And I'm looking forward to more opportunities to organize similar activities in the future so as to jointly promote in-depth understanding and cooperation among all parties in the field of global trade and investment law. Thank you all. Okay, I think it's now the end of this today's webinar, and thank you all for participating in today's fantastic discussion. Thank you all.